So welcome. This is the second in our webinar series, focusing on JobKeeper, but also talking more importantly today in some ways about the employment law issues. And that is an area of expertise that we don't talk on. We can talk to you about JobKeeper. In fact, I can talk about it all day, every day, and that seems to be what I'm doing at the moment. But I have an expert, Justine, here today, who is going to shed some light on the employment law matters, because that is outside the scope of what we will do. Now, my name is Sally Preston and I'm a director at Moore Stephens, and thank you very much for taking the time to spend an hour of your day with us this morning. So I'll just run you through some administration. What we have got is the chat box open along the side. Everyone should be muted and their videos off. Feel free to drop questions in that chat box. And I've got Kerry, one of the directors at Moore Stephens, monitoring that, because it will be a distraction to me to watch the comments come up and I don't want to sort of lose focus. So she'll jump in at the last bit, and if you've got questions that we feel like we need to be good to ask and answer, then she'll come in and ask those questions at the end. So feel free, or interrupt us as we go through if it's something that we need to clarify at the time. Now, I'll introduce Justine a bit more thoroughly. She's an employment lawyer and she's been working solidly the past few months on working with businesses across a broad range of industries and dealing with the impact of COVID-19, of the coronavirus, and what it has on their business operations and on their employees. So today she's going to concentrate on the JobKeeper scheme, as well as the changes that happened to the Fair Work Act to go in line with JobKeeper. We've got a bunch of questions that we listed in our invitation that we're going to run through, as well as some that came through in advance. The format for today is we're going to quickly run through a bit of an update on JobKeeper from me. Then I'm going to ask these questions to our expert, Justine, and she's going to run through, as I said, stuff beyond the scope of our knowledge and our expertise. And then we'll hopefully have some time at the very end to answer your live questions as they come in. So let's get into it. Okay, so JobKeeper. Most of you will know that the JobKeeper registrations opened this week. The ATO is still frantically trying to give us some information, and I expect that over the next couple of weeks we'll still be getting information. What we do know is on day one, and I expected it, that they had some glitches in their system. So if you're going ahead to register your business and you had problems on Monday or even Tuesday because of circumstances, the ATO is aware of them and they are working on them. So go back in and try again. There's no workaround. You need to answer the questions properly. So that's more if you've got an eligible business participant, they were having some problems with that. The ATO has also updated their website with a lot of information about what the steps you need to go through as an employer, and the things that you need to complete before you go and register, really, as well as things like we're seeing the software providers update software to cater for accounting for JobKeeper payments. So if you're not sure about how you're supposed to account for them, your software provider, most of them that we've looked at, have got instructions on how to do that, or we can help you with that. Okay, so make contact to your Moore Stephens advisor. The common questions we're still getting. Now, you'll remember from last week's webinar, if you dialed, and if you didn't, I'll quickly run through the main considerations for JobKeeper that you need to think about. The first one is you need an eligible entity. So you need to go through and test that your entity is going to be eligible. And in that, it's the turnover test that seems to be getting us more traffic on questions. There are two ways to test your eligibility. One is the basic test, which is your drop in revenue, or your drop in GST turnover from one period this year to an equivalent period last year. Now, that can be months testing. So for the month of April, you might test April against last April. It might be the quarter starting 1 April and the 30 June quarter, and testing that compared to last year. You don't have to stick with month or quarter based on how you lodge your BAS. Okay, so you can deviate from your BAS lodgement without actually changing your BAS lodgement. Okay, so that's an important thing. I've just got someone coming through. That's an important thing for you to note, is that you don't have to go in line with your BAS lodgement cycle. It just might be easier if you can. Okay, so that's the basic test that we've talked a fair bit about. The other one is the alternative test, and the ATO's put out a little bit more information, but what I want to do is the two examples that we've got so far and that we are expecting the ATO to release a ruling on is where you're a startup business or where you had things that happened last year that affected your turnover, so therefore you're going to struggle to meet the requirements of the basic test, okay? They're currently working on putting out their determinations or practice statements or whatever it is they're going to put out on those two scenarios. We're hoping for some more. But you might not be able to register because you actually can't make that assessment yet because you don't fall into the basic test and we don't have enough guidance on the alternative test. The good news is, even if you think you may be eligible to get payments that commenced on the 30th of March, the ATO has now said you've got until the end of May to register to get those payments, okay? So don't panic. We still have time, and the ATO is conscious that they have not put out enough information for certain businesses to undertake their assessment properly. Okay, the main thing is that the eligibility, the questions we've had in lead up to this one, a lot were about how do I know I'm allowed or I'm eligible for it? This is self-assessment, okay? You must do the work or have your advisor do the work. Okay, entering into or registering is telling the ATO that you are eligible. You've done the work. If you're registering and hoping the ATO is going to tell you whether you're eligible, they're not going to. What they're going to do is pay you based on the employees you then register for the first 2 fortnights. And after that, they'll have hopefully a chance to catch up and they'll start looking more likely at your employees to make sure they're not getting it from somebody else, that they agree they're an eligible employee. What they won't be able to do at that stage is you will be required to tell them your GST turnover for the month and for the next month. They'll probably have to use that to just double check that you've done the work. But if you've got that wrong, they're not going to know unless they come and look at it more closely. Okay, so it is self-assessment. So there won't be a statement that comes out from the ATO or a letter saying you are eligible for JobKeeper. So I wouldn't be sitting there expecting it. Okay, it's self-assessed. They will start to scrutinise what you lodge after they get through this first 2 fortnights pay. So I think that's really important. I think that's been missed by a lot of businesses, and I kind of need you to understand that. So that might, unless you had a pretty vanilla situation, so you're a cafe with all permanent part-time that have been there since 1 March or before 1 March, your doors are now shut, so it's quite clear you're going to meet the eligibility criteria. I would be recommending you get your advisor to help you before you register. Now, that might be your more Stevens advisor. You might actually be using somebody else. That's okay. But this stuff is complicated, and I wouldn't like you to go ahead thinking the ATO is going to double check for you. They're not going to until it's too late. Okay, so we've got an eligible entity. We've done that assessment. We've done the work around it. We're registering. We've got eligible people is the other one that we're getting questions on still. Not as much because we covered a lot of that in the last webinar. So remember, they're people that were on your books at 1 March and they were part-time, full-time or long-term casuals, okay? So I'm just muting somebody, sorry. That's also really important that you, sorry, if people are dialing in and they're not muted, can you please mute? Sorry, I don't have to go through and do everybody manually. Okay, that better? Sorry. Technical. Okay, so where was I? So eligible people, so long-term casuals. And so looking at the definition of that is something you might need some help with. So you've got eligible entity, eligible people, and remember it's about payments being made and the right paperwork being done. So you need to pay in advance. That's really important. And that's one of the considerations for employers maybe not wanting to register. And there's also paperwork. So before you go ahead and make the decision as an employer to register, you really need to understand all the things that you're going to be required to do. Now, the decision for you to register, well, you need to make the decision that you're committed to the system by the time you register. Why wouldn't you register? Well, it's going to take a little bit of work. So for one thing, you have to pay the wages in advance. So that's a cash flow and a financing issue for some employers. The other one is that you're probably going to need professional advice, and there's a cost that goes with that. So going into a system like this, as I said, unless you're vanilla, you really do need to be getting some assistance before you register, or even just getting the registration right to start with. And that's got a cost associated with it. There's a big impost on employers as well from the administration standpoint, because there is monthly reporting, and that's going to require you to, I guess, do accounts up to date more often, and also there's some changes into your bookkeeping system to account for this. And some employers will think that they can go alone. So they'll go, I don't really need JobKeeper, and I'm still paying, and I might have dropped in revenue, and it's just not worth a hassle. But the other thing as an employer to think about is some employees might really want you to go into it. For example, a part-timer earning only $900 a fortnight might go, well, if you don't go into it, I don't get my $1,500. But you've got to weigh up that upside for that employee versus the cost to you. And there's a lot of questions in there. But once you're committed, you're in. The other thing we need to understand is all eligible employees must be offered it. There is no ability for you to pick and choose, okay? And that's where the employment law, I guess, overlaps quite strongly, is we can get you into the system, and they made changes to the Fair Work Act that Justine's going to talk about to cater for these businesses which they're saying have a significant reduction of turnover and make life a little bit easier in some regards. But once you're in, you can't say to an employee, well, I've got no work for you and I don't really want to give you the JobKeeper, or the employee says, I don't want to come to work, and we'll talk about that, because that's not something that is not happening around. It's certainly something that people are facing, is an employee saying, I don't want to come to work, and I know you have to give me JobKeeper. And that is the case. You do need to give them JobKeeper if they're still your employee and they're eligible, okay, and you're in the system. So we'll talk a little bit about that. But today's content is really going to be around this employment aspect of JobKeeper. If you've got questions about JobKeeper registrations, eligibility, and those sorts of questions, please make sure you jump on and make those comments. I hope I've cleared a lot of the air on the pre-questions that I think we got. Some of them were along the lines of we have eligibility, and remember the eligibility date was, were they your employee at 1 March? So if they were hired and became an employee after 1 March, they won't be eligible to JobKeeper for JobKeeper from you. They must also stay employed. If they all of a sudden you make them redundant in June, they will not be eligible for JobKeeper from you. If that employment relationship severs, that is a test that happens every fortnight, every time they get a payment, is are they actually eligible? If they turn around and go on paid parental leave, government paid parental leave, they are not eligible for any fortnight in which they get any of that payment. Okay, so there's some so some employees will fall in and out because of those sorts of payments. Others will just simply not be eligible from the start, and some might stop being eligible because of other criteria that aren't being met. And that's not a test that happens once, that's a test that happens for every payment you make. And every time you put a submission into the ATO, you're telling them that you've undertaken the assessment and they are eligible. And as I said, after the first 2 fortnights, the ATO will be double checking that against the data they have available to them. So I want to throw it over to Justine now, because she is the expert on some of these things that I guess we get asked on and don't want to answer. And that's why Justine's here for her expertise. So Justine, I mentioned before the changes to the Fair Work Act and the JobKeeper enabling directions that come with that. Can you run us through what happened? What's
Is
changed?
your whole thing muted?
Absolutely.
Let me just go on mute. We good? Just got Justine and I now.
Thanks, Sally. So hello everyone. Obviously this is consuming everyone's business lives and probably personal lives as well, and probably will for some time. Some of the key points that Sally's already touched on are really critical to get advice and understand where your business is sitting. If you are qualifying for JobKeeper and you're eligible for those payments that you need and must by law pass on to your employees, it is only then that the new Fair Work Act provisions will apply. So if you're not yet eligible for JobKeeper or you've ruled it out and decided not to go down that path, these temporary changes to the Fair Work Act are not available to you. So it's really important to make sure that you have got all of that advice and vetting around whether you're qualifying and eligible for JobKeeper before you even look at the mechanisms that you will now have available under the Fair Work Act. Why? Because there are penalty provisions. So if you get this wrong and you start applying some of these directions and you're not legally entitled to use them, there are penalties of up to 126 grand per breach of the Fair Work Act. So not unlike other Fair Work Act provisions that if you fall foul of them, as we know, we've all heard about underpayment claims and prosecutions and that resulting in significant fines. This is no different. So the government has put really strict parameters around what businesses that are in the JobKeeper scheme can do to then manage their staff. The last thing any business wants at this point in time is to end up on the news. And we've seen yesterday in the media a dress shop in Adelaide and the text exchange between the employee and the owner of the business about the employee not wanting to work, the business not wanting to pay until they get JobKeeper, and that text exchange and all the sort of details going into the public arena and potentially impacting both the reputation of the employee and the employer. So these are temporary provisions that you can access, but only if you've ticked all those boxes for JobKeeper, and we can't reiterate that enough. The last thing any business wants out of this is you get it wrong, you end up with a dispute, you end up with the union in your business making applications to the Fair Work Commission and hamstringing you or stopping you from being able to effectively operate and manage your business. We've already seen that with one case that's come through the Fair Work Commission recently, where a business was actually stopped from being able to make employees redundant until they followed all of the orders that the Fair Work Commission had imposed on them. So you can imagine if you get into that situation and the operational decisions of the business are being taken out of your hands, it's just an added layer of cost, stress, distraction, and the like. So you're better off being methodical at the front end, get the right accounting advice on JobKeeper, make sure you tick all of those boxes and understand where you sit with it. Then you can access the temporary provisions under the Fair Work Act. They're in place for 6 months, so they're only in place until the 28th of September at this point in time. Who knows what's going to happen between now and then and what the world's going to look like, but for now, those temporary provisions basically give you a lot more flexibility than you currently have in your employment relationship with your employees. So what these JobKeeper enabling directions, which is what they're calling them, will allow you to do is respond to that reduction in work in your business by being able to direct employees to reduce the hours that they're working within your business. There are limitations to that though, so it's not a free-for-all where every business can go, you beauty, I don't want to pay anyone more than $1,500 a fortnight, I'm going to reduce everyone's hours down to $1,500, I'm going to move up, my casuals and part-time, so the government's paying my wages bill in effect. It doesn't work like that. The only basis on which you can use these JobKeeper enabling directions is if the employee cannot be usefully employed. So there's still similar tests to stand down. So we know stand downs have been used recently, mostly in the hospitality, retail, cafe sector, where there's been government mandates to shut businesses down. They can't operate. They literally have a stoppage of work It's no work for the employee to do, and so they've been able to utilise the old stand-down provisions under the Fair Work Act. Here, similar type of test, they cannot be usefully employed. So you can't conceivably have a full-time employee with 38 hours a week and a casual employee on 4 hours a week and adjust the full-timer to give the hours to the casual. You need to be able to demonstrate that full-timer, to reduce those hours or the days that they're working, can't actually be usefully employed, and you've got work there. So you really need to be very careful in when you're going to use a JobKeeper enabling direction, and make sure you understand and can tick again off all of that criteria before you start firing off those sorts of directions. The government has included provisions in these, so unlike the stand downs we have currently under the Fair Work Act, where there's stoppage of work and then a stand down is immediate, in this case you've actually got to go through quite a process. It's not onerous, it's not overly long, but it is a process. You'll need to be able to show you followed it. You'll need the documentation to back you up if you're ever challenged on it. So you've got to do a notification process and a consultation process with those employees before you start enacting it. So there's a little bit of detail there that all employers, if they're eligible for JobKeeper, should be across, and at least know and understand these are the other measures that are available to my business if I need them. There will be other flexibility provisions as well. So if you've got a limitation, for example, on the work that you now have available in your business, you can direct employees, so long as it's within their skill set and their competency and it's safe, you can direct them to do other different duties within the business. You could even direct them to work from different locations. So say, for example, you have 2 sites and one's been impacted by COVID-19 and shut down. You could effectively direct those employees to move over to your remaining location and perhaps perform work that they didn't otherwise perform. So there are definitely new flexibilities in there. You can also now reach agreement, you can now direct an employee onto annual leave. The provisions that exist now in modern awards and in enterprise agreements do have a number of roadblocks in terms of a business being able to quickly direct an employee onto annual leave or long service leave. It seems absurd in the environment we're in that you've got these roadblocks you can't navigate. So part of these new changes enable a business to direct an employee to take annual leave. And they also have introduced the capacity to put an employee or agree with an employee to take annual leave on half pay, to in effect get rid of that leave accrual off the books or reduce it down. The employee can still get paid, and you can in effect have them go on annual leave for twice as long at half the pay. That needs to be by agreement though. So again, these are not all things that the business can now just quickly and automatically do once they're qualified for JobKeeper. You've got to follow the process, and you've got to make sure you tick those boxes in terms of reducing your hours of work because of the impact of COVID-19, or because say for example your business has been shut down because of a diagnosed case and you've got a period of time in which you can't operate. You can use those new JobKeeper enabling stand down provisions to reduce the hours of your employees down to 0. But the importance is that you can't misuse them. So if you do, you really putting the business at risk. And we can talk about, I think we've got another question about, but what if I don't comply with all of these? They're no different to what we're dealing with, or have previously before this, with underpayments and prosecutions and fines and all that reputational risk going out in the media when employers haven't been following minimum wage requirements under modern awards and the like. So you really still need to think about this as a legal framework, but it does give you some extra flexibility you don't actually otherwise have at the moment to manage the reduction in work that you have in your business. So sorry, that was a really long answer, Sally. But
that's all right. I think you covered a few of them, but actually off the back of that, now this isn't on the question list, so let's see how you go. I'm an employee. The business isn't going well, I know that, and all of a sudden I get a letter from an employer that says, we'd like you to take your annual leave at half pay because we don't have enough work for you to work full time anymore. Why would I do that and chew my annual leave up, if they could simply, I mean, annual leave is going to give me salary, but say I only earn, $2,000 and I know I'll get $1,500 JobKeeper regardless. Why would I ever chew up my annual leave?
Yeah, so these new provisions will actually allow the employer to direct the employee. So there are only limited circumstances at the moment when there's excessive annual leave that an employer can do that. So from an employer's perspective, that's a cost to their business that they've got to have the cash funds for at some point. So the employee won't actually have a choice if that direction is coming through these new JobKeeper schemes. Some of the awards have also been changed to enable an employer to direct an employee onto annual leave. So in certain circumstances, the employee is not going to have a choice. The business has made that decision. We've got that cost liability. We need to get that down overall off the books. And so if the employee doesn't consent to taking that leave, there will now be the power for the employer to direct them. There are still minimum accruals that must be left. So under JobKeeper, the employee still has to have 2 weeks of annual leave left at the end. So it's not reducing it down to zero so that they can't ever take a holiday again for another 12 months, although that's debatable because there's probably nowhere to go at the moment anyway, to enjoy a break other than at your house. So a staycation maybe. But yeah, that choice is going to be something the business can impose on employees. The half pay issue though is something that needs to be agreed with the employee. And it's a bit of compromise. So I think the expectation is that everyone treats each other as a human here and that we're all going through this. So you really want your employees to be working with the business working with the employees. If that's not happening, we have these abilities where the business can direct these changes into the arrangements with the employees. But the other option or benefit of it is it just spaces out the pay for the employee so that they're not then going on leave without pay immediately, and they can adjust. So they can adjust their direct debits, their mortgage payments, talk to their bank, and all of those sorts of things. So there's pros and cons on both sides. In terms of that, there's been a lot of commentary out there about, employers will now start to go and run down leave accruals of employees. But that's a cost that the business bears, that if it does look to redundancies, for example, it's got to pay that accrued annual leave out, and in some circumstances, the long service leave out. So it's money the business needs to be able to ensure that it can pay those entitlements out. It's another mechanism, if we look at it that way, it's another mechanism of the employee being able to be paid instead of perhaps being reduced down their hours and then not actually getting paid, in that circumstance. So there's definitely pros and cons on both sides.
So if I've received my letter from my employer and it advises me that they are going to be entering into the JobKeeper scheme and that they'd like to nominate me as an eligible employee, I fill in my form, I send it back to the employer who keeps it for their records. They then go and complete their paperwork with the ATO to say, Sally is an eligible employee and we're paying her the $1,500 in advance, or more if their salary and wages are more than that, and therefore we'd like to be reimbursed the $1,500. Why, if I was, say I was a part-timer and I earned we'll go with the $900 a fortnight.
Yep.
And I know that I'm going to get the $1,500, but I'm afraid to go to work because of the coronavirus.
That's a good question.
Now, I can't work from home. I work in an industry that if I'm not at work, I cannot work. I don't want to come to work. I'm going to invoke, do I have a right to say, I'm afraid, I'm not coming, and I know full well I'm going to get my $1,500 to sit at home?
Yeah. So we've got to remember here that we've got changes to the Fair Work Act that are coming into play to assist those businesses that are being significantly impacted by COVID-19. All of the usual employment rules and parameters, modern awards, employment contracts, enterprise agreements, are all still in operation. So they haven't just magically disappeared because we've got these new provisions. They're just giving you a bit of flexibility to be able to respond. So if you've got an employee that says, I'm at high risk of COVID-19, or someone in my immediate household is at high risk of COVID-19 and I don't want to take the risk, there's no capacity for me to be able to work at home. I physically need to come into the office. I've got to catch the bus. I don't want to be on public transport. I just don't want to come to work. Then that's an issue for the employee being ready, willing and able to work. If they choose not to attend work and the employer is prepared to accept that, again, as a human going, okay, well, operationally, we can survive without Sally in the business for a period of time, then you need to look at, well, what are the arrangements that need to be in place? The employee is not ready, willing and able to work. So their normal pay, if they were earning their $900 per fortnight, is going to be picked up by a JobKeeper. But you'd be wanting to look at, well, look, is there other leave entitlements that could be taken? And you'd be wanting to verify that. So an employee can't just say, I don't want to come to work today without justifying that. So you'd want to be testing them on, are you sick? Is there a personal carers leave issue here, and that you should be actually taking that personal carers leave? Just because an employee is working from home doesn't mean that they'll be on occasion unwell, where they shouldn't actually be working. No different when they're working at home to physically coming into the office. There will be most likely scenarios like that where the employee says, well, actually, I don't want to come to work. You'd really want to be road testing that and getting a proper understanding of that before you agree to that, and facilitated the employee no longer performing that work that they're required to work for the $900 per week or per fortnight. There's going to be lots of these issues coming up, and we're expecting a lot of these issues will be challenged early on in the Fair Work Commission. So there will, I've got a blog on my website. We're updating as these decisions are coming through. There will no doubt be issues around this. The one in the media yesterday was around, the employer actually wanting the employee to work more hours. So they, perceived to get the value of the $1,500 of work out of the employee that was otherwise working for less. So there's going to be lots of these issues where we'll have opportunistic employees, opportunistic employers. They're not treated any differently in the sense of the obligations on the employee to be ready, willing and able to attend and do work, however that looks like in the new world of COVID-19, and the business giving those directions to ensure that they're safe. The employer ultimately chooses that they don't want to work. In this scenario, you would really want to be road testing that and understanding what that is before you accepted that they weren't going to come in and do their $900 a fortnight hours to earn that money. Yeah, and operationally, I mean, you might need them in the business, and there's not that genuine risk there. There might be adjustments you can make for the employee. If they're working, for example, in an open call centre, I'm sure most businesses have already accommodated or should have accommodated the social distancing rules. So most businesses should be in a position now where their workplace is as safe as it can be in light of the crisis and the virus. So there'll be lots of those issues coming up. There's no one answer fits all. You would need to be looking at things like employment agreements, the modern awards, what's reasonable, getting the employee to vet and verify on what basis they're choosing to be absent from work as well before that's accepted by the business. And you don't want a free-for-all here where every employee decides, nah, I'm just going to stay at home and get my $1,500 and do nothing. That might become a disciplinary issue where you might have circumstances that would warrant termination of their employment as well.
So I've got sitting beside Sally then. Let's change the scenario. Sally is a bit of a taking the opportunity of the JobKeeper. And then I've got sitting beside her Pam. Now, Pam likes to work hard. Pam sees that, well, Sally's not doing her job, and the employer has now asked Pam to pick up the extra hours. You mentioned it before. If an employer says, well, I've got JobKeeper and I've got someone that earns $900 pay because Sally and Pam work the same hours, I now want Pam to pick up what Sally's not doing. So Pam, I'd like you to work up to your $1,500. It doesn't cost me anything other than super. And I'm not paying Sally super because she's not turning up to work. So I'm in a neutral position and I need the work done.
Yeah.
Can the employer make Pam take the extra hours?
Yeah, so coming back to the earlier point, the normal rules with regards to employment still apply. They haven't disappeared. So you'd need to have a look at your industrial instruments. So whether you're operating under a modern award, which is most likely the case, an employment contract or an enterprise agreement, there will be mechanisms in there. If Pam's a casual employee, they're variable hours usually per week, so that might be subject to a roster, availability, and all of those sorts of things. If they're a part-timer, there are provisions within modern awards where if there's a variation of those hours, there needs to be notice given, and that notice might be a week or 2 weeks, depending on what the modern award says. And it might need to be varied by agreement so that you don't then inadvertently end up with an overtime claim from Pam to say, well, I'm working the extra hours as a part-timer, and so I'm eligible for overtime. So you really want to be having a good look at what the industrial instrument that operates and what you can utilise there in terms of giving Pam the extra hours, making sure you're covering the business from any potential additional overtime claims and those sorts of things. Remember that through all of this too, an employer can give what's called reasonable and lawful directions to an employee in terms of those things. We can change duties, we can change locations, we can reduce hours under the new Fair Work Act provisions. We've still got all of those provisions under modern awards, contracts and the like, where you could conceivably vary an employee's hours up. How easily you can do that and what that framework needs to look like will be sitting probably in that industrial instrument. So what I would say to employers that haven't already, get a really good understanding of what your industrial instruments are in your business. I've probably done more advice work on what's our modern award in the last sort of 4 or 5 weeks than I've done in my entire legal career, because businesses are, oh, hang on, there's some new provisions in the class award, can we use them? Because we've never, surprisingly, looked at what modern award actually covers the employees or the employer in the business. So go back and, if there's 2 things you do after today's webinar from an employment perspective, one is looking at what is the employment contract, pulling those out of personnel files, getting an understanding of the modern award. Go and have a look at it and see what you can do under it, because those provisions haven't changed. And the second is also get a good level of visibility over what leave accruals you do have in the business. So I've got a client at the moment that's got very long-serving employees in the business, and they are expecting to have a delayed onset of COVID-19 impact in their business. So they haven't been affected yet. They had a big spike in their operations, and they're now expecting that to plummet. So we've projected short term what's going to happen, what do we need. It's business as usual for them, luckily, and they've actually needed to increase hours for the employees. But we're expecting in the next 2 months that their work is going to plummet and they won't actually have enough work for all of their employees. So what we've done now is in each of the states they're operating in, we've got an understanding of how long do we need to give a direction for an employee to take long service leave, because they have very long serving employees in the business. So we've already mobilised and given directions to employees about the taking of long service leave in accordance with each of those states, because the legislation is sitting in each of the states, so that we're already got strategies in place to deal with the delayed onset of COVID-19 in their business now for 2 months' time. So go and have a look at those things. Have you got long-serving employees? Have they got excessive leave, annual leave, long service leave? Do you have other leave in your business that you offer that you can use as a strategy as well to manage the fact that your business will have less work for your employees to do? And really what you need to be looking at is, what do you need now to survive the crisis? What do you need, with a bit of a crystal ball, what do you need at the back end? Do we actually need these employees at the back end, or is that work disappeared and never going to return? Or do we need to retain them at all costs? So the leave strategy is a good one in terms of getting the employee through the next 6 months in a way that enables them to survive financially. They've got the leave there, you can direct them to use it, or you can get them to agree to use it, and your half leave even just allows you to extend that out so you can come out the back end with the employees you need, albeit with reduced leave entitlements, but you've got through that process with the least amount of impact for both sides.
Well, it looks like there's a lot of questions coming through. I've got a couple more myself before we jump over to those live questions. And I think you've covered a lot, Justine. I'm just having a look through what we had intended to cover in advance.
So I think, Sally, one of them was the pros and cons.
Pros and cons stand down. Yeah, pros and cons of stand down versus redundancy, I think, is one that we probably haven't touched on so much.
And it's if your business hasn't factored this into your considerations yet, you need to do that now, particularly with JobKeeper. I think a lot of businesses have realised that JobKeeper is great, and it's going to resolve a short-term cash flow problem in a business because it's acting in effect as a wages subsidy, but it won't stop the clock. Your employees are still on the books. They're still accruing leave entitlements. They're still accruing service for notice of termination and redundancy. So it again goes back to, you know, the two-part puzzle here, where you need to look at what do we need now operationally and from a cost perspective. What do we think we need at the back end? And so what might be attractive to some businesses in getting JobKeeper, utilising the JobKeeper enabling stand downs to reduce the hours down to zero if they needed to, where there isn't enough work for employees, is an attractive proposition if they need them at the back end. But that's not stopping the clock. A stand down doesn't stop the clock. So they're still accruing all of those leave entitlements. It wouldn't, and service entitlements. So it wouldn't make sense to utilise JobKeeper, utilise the stand down, get to end of COVID-19 and go, actually, we're never going to have a job for them anyway. We need to now make them redundant. You've got a bigger cost of the redundancy because you've got that 6 months of additional service with additional leave, possibly additional notice, possibly additional severance. So the stand down and the JobKeeper enabling stand downs are great if you are expecting to need those employees in some capacity going forward. If you don't, then a redundancy situation might be more suitable, and not necessarily for all of your staff. There might be particular staff where the job is going to go away, or you've got 5 Sallys and 1 Pam, and so you decide, okay, well, we only need 3 Sallys and 1 Pam going forward. But redundancies cost money. So there's probably, this certainly hasn't been like the GFC. In the GFC, as an employment lawyer, literally all I did, which felt like for about 3 years, was restructures and redundancies, because the business was gone. It was very clear cut, very black and white. The job is gone, the business is gone, the employment is now at an end. In this case, it's not so clear cut. So you really got to start making projections to the best you can to go, do we need all of these employees at the back end or not? And you'd be wanting to make some adjustments to your numbers if you were expecting that you needed a lower number of staffs later. There are provisions under the Fair Work Act, though, if you're in a situation where you literally don't have enough cash, you question whether you're going to get through the COVID-19 scenario anyway. There is an application you can make to the Fair Work Commission to reduce redundancy down to zero. There's been a few of those decisions just coming through the Fair Work Commission more recently. The Commission will want you to be able to establish the financial basis for that. So if you've got cash in the bank, it is very unlikely that you will be able to go to the Fair Work Commission and say, we can't afford to pay the redundancy severance pay for the employees. So you need to think about that from a cash flow perspective as well. It might even be that, yes, we need to make employees redundant, but we might have to do it on a staggered basis to manage cash flow. So, you know, that's an immediate cost, but it severs the employment relationship. It's also going to sever JobKeeper for that employee once you terminate them. And remember, you've got that ongoing obligation, as you mentioned, Sally, to report to the ATOs. So the last thing you want to be doing is an employee resigns, you terminate them or make them redundant. You forget to tell the ATO, you still keep getting that $1,500 a fortnight, and then you've got a bill to pay back to the ATO because you've been overpaid on JobKeeper. So you've always got to be remembering when you're doing that reporting to make sure you're giving them an updated information on which employees are now no longer with you. And just on that, in terms of terminations, you know, as I said, all of these employment provisions still operate. So if you've got an employee that's engaging in serious misconduct, poor performance, and that's going to be an issue that is going to be really hard to manage when people are working from home and probably significantly less supervised than before, and you're relying on them to be productive. They're trying to homeschool children and all of that sort of stuff. But there's no prohibitions with these changes to the Fair Work Act or any of the other changes that have come through that prevents an employer from being able to manage its employees as it would normally, giving them lawful and reasonable directions, managing performance, disciplining them if that's warranted, and following those normal processes if that's going to occur. But if you're getting JobKeeper, just remember you need to let the ATO know that they're no longer an employee in the business, so you're not inadvertently getting that money.
Good point. Look, I think we've got through a lot of the content, and I think there seems to be a lot of questions coming through. So I'm wondering, Kerry, are you there?
Yes, Sally, I'm here. Good morning.
You are. Hi, Kerry.
How are you?
Good. I've tried to read it, but you ladies know that my contact lenses don't work on a small screen very well, so I can't read it. I've tried. I can lean right in.
I've been sorting the questions. We're going to leave the questions that are to do with JobKeeper and questions we can answer Sally later on. So
correct.
Mostly questions for Justine I'll concentrate on.
Great.
So here we go. We've got quite a few. If employees have resigned during March, even though they were employed and they've sort of said this is too much for me, is that okay not to include them as eligible employees for JobKeeper?
Yeah, that's a good question, actually. So you will have already paid that employee up until their resignation date. And so I guess there's the practical issue that you can't actually go and get them nominated if you're no longer in contact with them to get them to fill out the form. They might be eligible for JobKeeper with another employee subsequent to their resignation that they obviously can go now and do. But that too, that window, I'm not sure what your thoughts are, Sally, but I don't know whether it would be.
Look, they have to have been on the books at 1 March. So if they've left you during March and taken another job in March, they won't be eligible from their next employer. But your decision still stands. So if you've made someone redundant post 1 March, so after that date, or they've resigned, then you have to make the choice as an employer about whether you want them back. So you still have the ability to say, I'm glad that they're gone, or I won't need them at the end. I made them redundant already. I've already dealt with that. They'll potentially come to you and ask if they're in a bit of a pickle and I can't get another job. They'll potentially come to you and say, will you take me back so I can get JobKeeper? That is still very much the employer's employment decision to make. And as Justine made it really, I think, clear, was that don't necessarily make those decisions if you're going to end up in a situation at the end where you either don't have them, don't need them, don't want them. You might, and if you do make the decision to take them because you want to do, a good thing for that person, even though you just need to be aware that you are accruing all those leave entitlements and the time period to make them redundant at the end, or hope that they resign. So I think the rules are, yes, left after 1 March, they are eligible if you rehire them and they accept it.
Yeah, sorry, I should have known that to answer that question. But the other issue is you've already paid them out the redundancy, right? So you paid them out all of their entitlements, annual leave, possibly long service leave, notice of termination and redundancies. What's going to happen with that if you do re-employ them? What you want to make sure of is if you're entering into a new employment contract to take them back on, that you set those things out really clearly, because you don't want to dispute about that later on. And you also need to be mindful that for things like long service leave, depending on the legislation in each state, it may actually be continuous service, even though there's been a short break in their employment. And so it might not necessarily start the clock again for long service leave. It might be that it goes back to the earliest start date. So there's quite a few issues in there. You really want to be making it very clear to the employee, either we've paid you out, so you're starting again. And so those entitlements that you've been paid out for, you might agree that they get repaid, but there'll be super and tax issues involved in that, or you just start the clock again, but keep in mind that things like long service leave might still be ticking along. And then I guess at the back end, I've already done a couple of those arrangements with clients as soon as they realised JobKeeper was there, looking to re-employ those employees. You need to look at, well, hang on, we actually don't need you on the full-time basis anymore. We've only got enough work for a part-timer, or we've only got 3 months of work left, so we'll give you a maximum term engagement or a casual type engagement for that period when you need them and you're bringing them back on. So yeah, there's lots of complexities in this, particularly where you've stopped and restarting an employment relationship. You need to be making the right commercial decision for your business, as well as obviously trying to be humane in this. Just because an employee is not getting JobKeeper doesn't mean they might not be able to access JobSeeker and other support through the government as well. So it's not a situation where you must take the employee back on. You'd be looking at all of those things before you made that decision. Yeah.
Thanks, Justine. We have another one with regard to leave accruals while people have been stood down. So one question was, currently we have reduced accruals based on the reduced hours prior to JobKeeper coming on, but now the hours, we have to accrue leave on normal hours.
Yeah,
so can we just cover that a little bit?
Yeah, so a lot of businesses, as they were impacted by COVID-19, did agreed variations to employment contracts. So I did a lot of that stuff a lot of that work at the front end of the crisis, where there was an immediate impact and there was only 4 days of work instead of 5 days. And so if you've agreed in writing and you've done a variation to your employment contract to reduce the contractual arrangements of an employee in terms of hours and salary, then there's an argument that that is now their normal. For employees that are on stand down though, so if you've utilised the stand down provisions under the Fair Work Act that were in existence before, and the employee has been not working and not getting paid, as I said before with stand down, that does not stop the clock. So they're still accruing all of those leave entitlements as they go through the stand down process. With the new stand down provisions under Fair Work Act, you're right, Kerry, they will continue to accrue their leave at their normal, whatever their normal rate is before, and their entitlements are before they're stood down through that mechanism. They still get the leave accruals based on that ordinary hourly engagement or full-time, part-time engagement. So you really need to be looking at, if you moved early on this and you reduced hours, reduced pay prior to these new JobKeeper enabling stand-down provisions, you need to be looking at, well, what did you agree with the employee? Have you done a proper variation to the employment contract? Because if you haven't, that there potentially is an argument for the employee to say, well, hang on, we didn't formally agree to that. There's no variation. I'm entitled to leave at the full-time rate prior to having my hours reduced. So you need to be looking at, again, it goes back to your industrial instrument and checking that, and also what's been agreed in, hopefully, in writing with an employee around those things, so you've got clarity. The main objective through all of this will be, the last thing any business will want at the back end of the crisis is an escalation of fair work claims, underpayment claims, the ATO coming back to them for overpayments and then trying to recoup that. All of those back end issues and disputes. If you take the time to get it right now, then you can minimise the risk of that happening. So it's a good insurance policy to get Sally to tick off, yep, qualified, yep, eligible, before you then come to us and get the legal advice on, okay, we now need to use JobKeeper stand down, and you follow the right process in that so that you don't end up with a dispute or a claim, potential fines, which, as I said, are not insignificant, the disruption in your business, and the reputational damage as well. You know, I was talking to a client yesterday who had 2 distinct businesses, and he'd run out of money in one of the businesses, and he wanted to just move them out effectively at 5 o'clock last night, and hadn't been thinking about the strategy to get in place to manage that reduced work and the reduced costs. Whatever he does in that business is going to impact on his bigger branded business, because he's attached to the 2. So you always need to be looking at that as well. You don't want to be one of those businesses that you get a disgruntled employee, you know, airing the text messages or emails that you've sent through on these things. You really want to be on solid ground and reasonable in the way you communicate with employees to effect all of these changes, and do it in writing to protect you. Do it properly at once at the front end.
Thanks, Justine. We have another one. I'll read this one verbatim. We run a time in lieu system due to variability in workflow. Do we have to make up to full time from time in lieu, even if this impacts on our cash flow before we start on reduced hours?
Yeah, so time in lieu is basically the extra hours you've worked for overtime. So I'm not sure how that would impact. I'm not sure that I follow that question. I'm happy to pick up with that participant at the back end. But
Okay.
again, all of those rules around time in lieu that are sitting in the business now aren't changed. So the question of whether you want to agree with the employees, or if you've got capacity to direct, to get them to take the time in lieu, like you might utilise them to take the leave first before you then start looking to reduce hours and reduce the arrangements in the business through these stand-down provisions or the other provisions you have available to you in the Modern Award and the Fair Work Act. So yeah, I'm happy to take that one offline, but I would say it would be as per your normal rules to use your time off in lieu as another option. And same with RDOs.
We have an employee who has been on work cover for 6 months. Work cover has ceased, but he has not been given clearance to come back to work. Is he eligible for JobKeeper?
Yeah, so as Sally mentioned really early on, there are a group of employees that will not be eligible for JobKeeper. One of those are employees that are on workers' compensation but that are not working. One of the groups that are included are employees that are on workers' compensation but have returned to work. That one falls through the cracks, and I don't know that that's actually being considered in the rules because the employee is no longer on workers' compensation, but they're not working. So they might actually be on a period of leave without pay, perhaps a paid or unpaid period of personal carers leave. If that's the case, then they will most likely be eligible for JobKeeper. So you really, again, you've got to look at what those particular arrangements with the employee are and make sure, again, you vet that with Sally and with us to make sure you've ticked those boxes before you go and make that application and receive the payment and pass it on, because you don't want to then be having the ATO come back to you to say, well, hang on, that employee wasn't eligible. And apparently that's what they will be doing, Sally, as I understand it, is they're not going to write to you to say you've qualified. They're going to vet the eligible employees and let you know if there's an employee that's not eligible. So you'd want to be knowing that very early on before you start making those payments to the employee. So that would be one you'd be wanting to check and road test with the ATO.
That was actually one of the questions, who is responsible for the repayment if it turns out that an employee isn't eligible. So
I think it depends on who's made the statement. So if the employee is not eligible because they have gone and got it from 2 employers, then the provisions let the ATO go to the employee. If the employee is not eligible because the employer is not eligible, that's an employer problem. So the employer needs to get the statement and act in good faith on the employee's statement, which is why those forms are so very important to have in their records. But they have to have undertaken the tick the box process and sometimes ask the ATO's opinion, I would expect in unique situations, to confirm that they are in fact an eligible employer to start with, because they will, if they're not an eligible employer because say their turnover drops by 20% only in the month that they believed it was 30 because they've done their assessment incorrectly, or they've made payments, they've received payments, the ATO doesn't catch up with the fact that they weren't eligible to start with, I believe that is going to be an employer problem. If the money's in the hands of the employees, we were talking about this beforehand, Justine and I, before we started, the employer, if the person has worked and they're entitled to the salary and wage, very much an employer problem. Buck stops there. If they're on stand down, then it's probably going to become a more legal issue and going through trying to get money back. And Justine can probably talk about that a bit more.
Yeah, the last thing you want to be doing is seeking recovery of money from an employee, particularly in these circumstances where everyone will be under some form of financial strain. I think, the stats out there are quite scary in terms of the number of employees that are now working reduced hours. You can't just go and withhold that money from an employee's subsequent pay. There are limitations on what you can do in the Fair Work Act to deduct monies or in terms of how an employee's pay is spent. The last thing you want to be doing is seeking a small claims court claim against an employee to try and recover money. So yeah, again, it's about getting the right advice to make sure that you can participate and that your business and those employees are eligible, and getting it documented, getting those records in place. As Sally said, if the employee has genuinely worked for those hours and was entitled to be paid, there's really no basis for the employer to be going back to the employee to recoup it. So that's where the business needs to be doing their checks and balances, making sure they get that declaration back from the employee. There is certainly scope for the ATO to come back to the employer and say, we've overpaid you, give us the money back. And they might not be concerned with how the employer may then recoup that money. They might just consider that that's the business's problem. There's scope for honest mistakes, though, as I understand it, Sally. So if you've made a genuine honest mistake and you can establish, well, look, we've got the accounting advice, we've got the legal advice, and there was an honest issue that's happened within the business, it might have just been a payroll error or something like that, then there is scope for the ATO to consider that as well.
Yeah, agree. Yeah, agree. Were there any others, Kerry? We're a bit over time now. Was there any?
We have quite a few, but I've taken down hopefully everybody's names, email addresses, so that we can answer them. Is that still the go this time? We're going to answer people individually if we can.
I'm still trying to answer all the queries we had from last Friday's webinar. So if you are online and you haven't received an email from me, I'm working through the list and I'm trying to get back to everybody. We will on the JobKeeper, but if you've got questions on employment law matters, Justine, what's your best contact? Is it the email that I've got? What's the business that they can go and look you up, or do you want us to send some details on contacting you? Or
yeah, we can certainly get some details across to you, Sally and Kerry, if you want to send them out to the participants today. So Rouse Lawyers is the contact. We've got me as the employment consultant, and we've got a commercial property team. So if you've got issues with leases, rent, you need rent relief, we've got a team that can assist you in that. If you've got commercial contracts that are implicated by COVID-19 as well, we've got that whole suite of legal support for you at Rouse Lawyers. So if you just look them up online and give us a call there, or just email admin@rouselawyers.com.au, so ROUSE, and we can certainly come back to you and assist you. Or otherwise, Google's your friend. That you'll find us on Google if you put our name in. Yeah.
And Justine, you mentioned beforehand the sort of packages you're doing for people, because of course, as soon as someone hears, I want to have a conversation with my lawyer, they hear, I don't know how much that's going to cost me, or how am I going to, how's that going to work? And I know you're doing some fixed pricing.
Yeah, so we'll definitely do fixed pricing for these types of matters. We appreciate clients need cost certainty, and we'd rather make sure that they get it right at the front end. We're very proactive lawyers in that sense. Look, it just depends on what you need. What I found, most clients need a 35-minute or 40 to 45-minute strategy session, so that we can understand what's happening now versus what's likely to happen, and then working out and there might be a multitude of strategies they need within that to manage the impact of COVID-19 as they go through it. So, initially there might be a few redundancies, but then we look at stand downs, we look at JobKeeper and the like. The way we're doing it is we'll do the initial consults to figure out what you need, and then we'll just do fixed type priced templates. So if you need to utilise the new JobKeeper stand down provisions, we can get you the template notices, some scripting if you need it to manage you through that process. If it's a redundancy, we can check which modern award that might apply, or whether the Fair Work Act provisions apply, and give you the templates that, on a cost-effective basis, you can then go and implement them in the business on a multitude of times with some really clear guidance. One I did yesterday, the client was like, oh, I've never done a redundancy before. I literally verbatim wrote out a script for him so he can sit on his Zoom call and make sure he gets it right, and he follows the whole process just by literally reading the scripting. Other clients just need some dot points. Other clients are comfortable with the template. So we'll really customise it to what you need. In terms of expense, it's a good insurance policy at the front end to get this stuff right, so you can avoid the expense and the distraction of claims later. Some of the templates we're doing, we can do as cheaply as, $100 or $200. They're not expensive to get you going. And the initial consult's just based on our time, so it's probably around the $250 mark for a half-hour consult with us. But we can put a package together for you. So really, for an investment of less than $1,000 in the scheme of things, it's a pretty good one to avoid the ATO and Fair Work Commission coming back at you at the back end. It just depends on what the client needs. So we're really trying to make sure we get the right package of support to clients. Yeah.
Perfect. Well, look, I know there's a lot of questions. I know this is an area that is of great concern. I'm involved in a lot of organisations, both at work and outside of work, with a lot of employees, and it can be stressful, particularly if you're the responsible person for, I guess, the welfare and the employment of a lot of people, and even just one person making sure the right outcome comes about is really important. So on the JobKeeper questions, we'll try and get back to you in the next, well, I said it before the next webinar last week, and I'm not getting quite there yet. So there were so many questions that I'm getting on a daily basis, but please engage with us. We are watching what is coming out from the ATO, and if anything else comes from Treasury. Every morning, it's my morning routine. I know that sounds really exciting for most people, but that's what I do. And so the team at Moore Stephens is well versed. They get spammed by me every day, multiple times a day, so they know the latest that's happening. So please contact us to help, particularly with these registrations. You've now got Justine's details to get help if you do need it for employment law. And look, thank you so much for participating yet again. And there might be more. We'll keep you posted on anything in the future. Thanks, guys.
Thanks, Sally.
Thanks, Kerry.
Thanks, Kerry. See you later.